You know, there are certain grown-up things in life that just kind of sneak up on you. For me, it was that moment holding my newborn, realizing, wow, I'm responsible for this tiny person's entire future. And suddenly, a topic I'd always put on the back burner, estate planning, felt incredibly urgent. It sounds super complicated, I know, but today we're going to break down one of the most powerful tools out there for protecting your family and everything you've worked for. So let's start with the big one, right? What actually happens to all your stuff when you're gone? If you don't have a specific plan in place, well, the government has a default plan for you. And let me tell you, it's a process you really want to avoid. And that process, we can think of it as the villain of our story today, is called probate. Most of us have probably heard the word, but we don't really understand the headache and the cost it can bring to our loved ones until it's way too late. To put it simply, probate is when the court system has to step in and manage your estate. If you don't leave a clear plan, a judge has to follow this rigid set of state rules to figure out who gets your house, your savings, your car, you name it. It's a one-size-fits-all solution that, let's be real, almost never fits any family's actual situation. So why is probate such a nightmare? Well, for starters, it can drag on for a year, sometimes even longer, locking up assets right when your family might need them the most. It's also shockingly expensive. Lawyers, court fees, appraisers, they all get paid before your family sees a penny. Oh, and it's public. Your family's finances become a public record. And maybe worst of all, it can turn into a battle royale, inviting relatives to argue over who gets what. And let's talk real numbers for a second. We're talking about 10 to 20% of your entire estate getting eaten up by probate fees. So on a $500,000 estate, that could be up to $100,000 that just vanishes, gone, before your kids or your spouse get anything. It's a huge blow. There has to be a better way, right? And thankfully, there is. This is where the hero of our story comes in, the Revocable Living Trust. You can think of it as your own personal shield, specifically designed to protect your legacy from all those threats we just talked about. Okay, don't let the fancy legal words scare you. At its heart, a living trust is just a legal container, like a box, that you create to hold your assets. You then pick someone, a trustee, to manage what's in that box for the people you want to benefit from it, your beneficiaries. Simple as that. So every trust has three main characters. There's the grantor, that's you, the one who creates it. There's the trustee, the manager. And there's the beneficiary, the person who gets the goods. But here's the really cool part. While you're alive, you can be all three. You create it, you manage it, and you benefit from it. You stay in complete control of everything. So, how does this actually work in practice? It's pretty straightforward. First, you create the trust document. Then you transfer your big assets, like the deed to your house or your bank accounts, into the name of the trust. So now, the trust technically owns them. And here is the magic trick. People die, but trusts don't. So when you pass away, the trust just keeps on living, and your chosen successor trustee can distribute the assets exactly how you wanted, completely sidestepping the probate court. No fuss, no wait. Now, a question I hear all the time is, hang on, isn't that what a will is for? And that's a fantastic question, because they do seem similar on the surface. But in reality, they are two very, very different tools. So let's break down the real differences. With a will, you still own everything. The will is basically just a set of instructions for the probate court to follow. It might make probate a bit simpler, but it doesn't avoid it. And it becomes a public court record. With a trust, the trust owns the property. It's a living thing that completely avoids probate from the get-go. And this is huge. It stays a completely private family document. Okay, so you're probably seeing why a trust is so powerful. Now let's get into the how, because just having a trust isn't quite enough. You want to set it up strategically to make sure that shield is absolutely rock solid. I love this next tip. It's such a brilliant modern idea from our source material. To make sure there was zero confusion about what he wanted, the author actually recorded a private video explaining the spirit of his trust. He wanted his own voice to clarify his intentions. It's an amazing way to make sure your wishes are perfectly and personally understood. So what are the key moves? First, be your own trustee. That way you keep full control. Second, the trust agreement itself needs to be crystal clear. This is your instruction manual. Third, you'll want something called a pour-over will. Think of it as a safety net that automatically catches any assets you might have forgotten to put in the trust and pours them in for you. And finally, you can add special clauses to protect your heirs from creditors or, hey, even from themselves. Now, it's really important to know that the living trust we've been talking about is just one type. Trusts are incredibly flexible. They're definitely not a one-size-fits-all kind of deal.
You can customize your trust in all sorts of ways. A support provision can make sure the money is there for essential things, like education or medical bills. A spendthrift provision is really powerful. It protects the inheritance if you're worried about a beneficiary's spending habits or them getting into debt. You can even set one up to benefit your favorite charity. The options let you tailor it perfectly to your family's needs.
Okay, I get it. This can feel like a really big project. And setting up a full trust does take some time and effort. But what if I told you there is one super powerful, super easy, and totally free step you can take literally today to start protecting some of your most important assets? Here it is. Log into your 401k, your IRA, and your life insurance accounts, and just double check that you have named specific people as beneficiaries. These types of accounts have a kind of superpower. They're considered non-probate assets, which means they pass directly to the people you name, completely bypassing probate. No trust needed. This literally takes 5 minutes, and it's a massive first step. At the end of the day, all of this planning isn't just about money and assets. It's about leaving behind a legacy of care and thoughtfulness instead of a legacy of confusion and stress. A little bit of planning now saves your family a world of pain later. Your legacy is really your final story. You've got the tools to make sure it's told exactly the way you want.